Good evening and welcome. My name is Mark Kinney, and I'm the Senior Vice President of Sales and Marketing for Independent Pharmacy Cooperative. Tonight, as part of the IPC webinar series, we are pleased to present Dan Toulouse, DEA Compliance Director for IPC. Dan has been leading IPC's Controlled Substance Compliance Department for over a year. Previously, he managed the IPC Suspicious Order Monitoring Program and conducted oversight on our due diligence requirements. He was also previously associated with IPC as a consultant, conducting site visits at our member stores and providing education and guidance on DEA compliance-related matters. I will now turn it over to Dan.
Hey, good evening, everyone. Thank you for joining me on this webinar tonight. As Mark mentioned, my name is Dan Toulouse, and I'm the Compliance Director. We have a lot to cover tonight, so I'm going to get through as much as I can. I know you're going to have a lot of questions, but we'll probably, answer a few of those at the end. But every question that you ask, we're going to capture, and I will respond back over the coming days. Linda is going to put those into a format for everybody to see. So, don't worry, we'll get to your questions. I have a unique perspective to share with you on the stuff I'm going to cover tonight. My former life was 30 years in law enforcement, 10 of those with DEA as a task force officer, and I did a lot of investigations into distributors and pharmacies and practitioners, both traditional investigation and working undercover. So I'm going to share some of that perspective as we go through this, and our whole goal is education, to keep you up and running, and we don't want you to get any type of fine or criminal violations. So I'm going to share some of that with you this evening. I just want to make a quick disclosure. What I have to offer is not legal advice, so you shouldn't take it as that. But I will offer, some suggestions. I'll offer insight. I'll tell you specifically what the federal regulations are, and then you should use that to make an educated judgment on how you want to run your business. You're all professionals, you're all well educated, so I'm not here to tell you how to run your business, but I do want to help you. So why is it important that you're here at this webinar, and why should you pay attention to this presentation? As you're all aware, there's a opioid epidemic. DEA has been under the gun to address this for a number of years, and they are out there. They are using every resource available to identify reckless practitioners, pharmacies, distributors, and manufacturers. They have a number of tools at their disposal. Some of those are administrative, civil, and criminal enforcement actions. We're going to talk about those towards the end of this presentation. DEA never used to show up at a pharmacy unless there was some type of criminal investigation or a complaint, but now, as part of their work plan, they have added pharmacies to their inspection schedule. So every field division in the U.S. Assigns their diversion investigators to go out and do an inspection at a pharmacy. So they're per quarter, and so at some point they're probably going to walk through your front door if they haven't already. So you should know what to expect. You want to know this ahead of time. You want to make sure you're ready for that. It's intimidating when they walk in, just for the mere fact that you're worried about, am I going to get in trouble? Have I done anything wrong? What are they looking for? So we're just going to kind of peel the layers of the onion back on that, and just make you more comfortable with the whole process. And a simple mistake, just a record-keeping mistake, could cost you a $15,000 fine. That's the minimum amount, and that's for every violation. So if you've had multiple record violations, the money could get, the fine could get really high. As an owner of an independent pharmacy, are you able to take that hit? Can your business and livelihood survive with a fine like that? So those are things you want to consider. Now, with all that said, I want to remind you, DEA really is looking to work in a cooperative manner with registrants. What they're seeking is voluntary compliance. That's, because if you're doing the right thing, they don't have to worry. So they do work with you. But if your house, so to speak, is not in order, they're going to fine you. And if it's something criminal, they're going to charge you. So let's go over some of the things that you need to worry about. So as a pharmacist, you might wonder, where do I fit into this whole picture? Well, the Controlled Substance Act of 1970 established a closed system that tracks and accounts for controlled substances from importation to manufacturing, through wholesale distribution, down through the pharmacy, and ultimately to the end user. As a pharmacist, you are the last link in the chain before that controlled substance is handed over to the end user. You are ultimately the last line of defense to prevent diversion. That's a lot of responsibility. Is it fair? Maybe not, but that is what it is. So you should recognize that, you should be aware of that, and you should take precautions to protect yourself, your business, and your livelihood. So what is this closed system of distribution? Well, DEA has the responsibility to establish schedules, schedules 1 through 5. They handle registrations. Every registrant, everybody that handles controls needs to be registered. They establish quotas, how much can be imported into the US, how much can be manufactured per year. They also establish what minimum security requirements are. They require certain record keeping that you must adhere to. They also have certain reporting requirements, and they also do scheduled inspections and audits. If you kind of go clockwise around this wheel, you can see the last 4 things are really what we're going to focus on. Those are the things that you really need to be concerned with. Although everybody needs to have a registration, and that's important too. The other things are typically what's going to get you in trouble. After you get out of pharmacy school, and either you were working for another pharmacy, or you started your own business, or later on in life you started your own business, you know the right thing to do. The majority of pharmacies that I go into do the right thing. It's the small things that build up over time that get you in trouble, and it's human nature. What happens is, as an independent pharmacy, you don't have the manpower like a big chain pharmacy does to throw more bodies at whatever the issue is. So, a lot of times you're just trying to make it through the day, and so you take just a tiny little shortcut, and over time that shortcut gets a little bigger and a little bigger and a little bigger, and after a while, as human nature has it, you justify it in your mind. You're like, that must be right. I've been doing it for a while. Well, what we're going to try and do here tonight is just remind you, refresh you on what the requirements are. We're going to bring you back to status quo and make sure you're doing the right thing. So the main instrument, well, let me back up a minute. For every controlled substance, there's a cradle to grave responsibility. Whatever it moves from point A to point B, there has to be some type of documentation, whether it's a 222, an invoice, a prescription, whatever it may be, until it gets to the end user. So for you, your major concern is the prescription, because you're getting it from the practitioner. It's coming from the practitioner to you, and then you have to make an informed decision on whether you're going to fill that or not. So let's look at what the law says about a valid prescription. A prescription for a controlled substance to be effective must be issued for a legitimate medical purpose. That's number 1. By an individual practitioner acting in the usual course of his or her professional practice. That's number 2. So in one aspect it's specific, in another it's kind of broad. What exactly does that mean? How do I get in trouble by not following that? Well, let's look a little more into that. So as a pharmacist, you have responsibilities as well. The responsibility for the proper prescribing and dispensing of controlled substances is upon the prescribing practitioner, but a corresponding responsibility rests with the pharmacist who fills that prescription. And that's also under the Code of Federal Regulations. It's very specific. So, you're kind of caught between a rock and a hard place. You have the responsibility to kind of know what's the doctor doing? Why did the doctor issue this prescription? Then you have to be responsible for what you're doing. Have you done all your checks? Are you filling it correctly? Are you giving the right advice? And then you need to know what the patient is doing. Are they doctor shopping? You know, are they trying to divert this drug? Is it really who it is? Have they, you know, is there some type of fraud with this script? So there's a lot of responsibility. Everybody else, the doctor, they just worry about what they do. The patient, they really don't worry about anything. The manufacturers, distributors, you know, they have some responsibility as well too. But as a pharmacist, it all rests on your shoulders. And although it's not fair, you know, we have to deal with that issue. So let's just, you know, I approach things with a positive attitude, a glass half full. So that's what I recommend to everybody I talk to, is just understand what your responsibility is and just approach things in that manner. So this, because of this corresponding responsibility, it creates this conflict between the pharmacist and the practitioner. And the problem is the majority of practitioners don't understand that you have this corresponding responsibility. So, you know as well as I do, many times when you contact a practitioner, right, they're arrogant, they're condescending. Who are you to question me? I write it, you fill it, end of conversation. Well, you need to stand up to that. You need to protect yourself. It's your DEA registration, it's your pharmacy license, it's your livelihood, it's your business, it's that of your community and also the people you employ. So, you know, I always believe in taking an approach of, you know, working together. So, you know, maybe you can develop a little spiel that you're going to use ahead of time and just, you know, inform them, hey, look, I'm just trying to do the right thing. You know, I don't know if you're aware or not, but the law also requires that I have a corresponding responsibility to know what you've done and why you've done it. And so I'm just trying to get that information. I want to put it in my files. That's it. And, you know, if it comes down to it, you can lay the blame on us, the wholesaler. You can say, look, they're asking me questions. I have to provide it or they're not going to supply me anymore, because that's a fact. You know, that's part of our due diligence process. So you can put the blame on us. What are some of your obligations? Because as we know, you know, the practice of medicine is easy because you as a pharmacist have to do everything. So you have a duty to act in the usual course of your professional practice. That sounds familiar, right? You have to do it in good faith, and you have to do it in accordance with generally accepted medical standards. That sounds familiar too. So what are these generally accepted medical standards? These include the 6 fundamentals of a doctor exam: medical history, personal and family, physical exam, appropriate tests, so they can arrive at a diagnosis. What is the diagnosis of the problem, course of treatment, and follow-up. Think about this. Think about your normal life ever since you've been a child all the way up to, you know, whatever age, stage of life you are now. What happens when you go to the doctor office? You walk in, you sign in, you have paperwork to fill out, you got to document your medical history. Eventually you get called back into the inner office. They take your vitals, check your weight. They ask you some follow-up questions, and then you wait for the practitioner. They come in, they ask some additional questions. They kind of go over your chart, and then they kind of, you know, zero in on what your chief complaint is. And then maybe there's some blood work or urine work to help diagnose the problem. Maybe there's some type of imaging, but they come up with a diagnosis. They come up with a course of treatment, and then there's follow-up. And then many times, many instances, there's the prescription is written, which then arrives at your pharmacy, and then you have to make a decision. So these are all things you should consider when you're evaluating that patient, that customer that's standing in front of you. Some of your other obligations: you have a duty to question a prescription of doubtful, questionable, or of suspicious origin, a duty to refuse to fill a prescription until that suspicion is resolved, and a duty to verify that the prescriber is properly licensed with the DEA and the state medical board. You got to make sure all these things are done. It's a lot. You also have a duty not to act with willful blindness or deliberate ignorance. You have a duty to act like a reasonable pharmacist in recognizing various red flags which create a level of concern that might cause a pharmacist to either choose not to fill that prescription or take some other action, like maybe calling the practitioner and asking more questions, maybe asking the patient more questions. But the bottom line is, you can't just stick your head in the sand and hope it goes away. You can't say, you know what, I didn't see it, my head was in the sand, so it's not my problem. You're going to get arrested if you do that, and I'm speaking from experience. And I can tell you from, you can read the news articles yourself, I'm sure you've all read them, but this is how it happens. If you just ignore it, it's going to become a problem. So address the problem head on. Well, let's talk about some of the red flags. I know a lot of you are familiar with some of them. You've probably encountered them several times, but let's go over them again. This is not all inclusive, but we're going to kind of hit some highlights. So a red flag is a circumstance that does or should raise a reasonable suspicion as to the validity of that prescription. At that point, you need to start asking some questions until you resolve that suspicion. Red flags typically have been interpreted to be more likely to reflect drug abuse, addiction, or diversion, which, we're talking about criminal activity basically. Various courts, time and time again, have determined that these red flags provide knowledge to the pharmacist, which cannot be deliberately ignored without violating the law. Again, you can't stick your head in the sand. Some common red flags that you should be looking for. The most obvious one are drugs known for diversion and abuse, right? A lot of your opioids are going to be at the top of the list. High quantities or dose prescribed, patients seeking early refills, patients traveling long distances to doctor or pharmacy. And again, I just want to stress, just because there is one red flag or two red flags doesn't mean, you throw out the baby with the bathwater, but you have to investigate those. You have to answer the question to take away that suspicion. So doctor shopping or pharmacy shopping, that's a big one. Patient behavior does not match their purported medical condition. As an example, you got somebody in there on, chronic pain, and they got a whole host of opioids, and bad back and all this stuff, and you see them and then they're slap happy with their buddy and they're doing jumping jacks. That should be a clue. You should be asking some questions. You probably should not fill that script. You have somebody in there on with a script for promethazine codeine, and while it takes maybe 30 minutes, 40 minutes to process it while they're waiting, and they don't cough once, that should be a clue. That should be a red flag. You probably shouldn't fill that without asking additional questions. And then patient admits to taking the controlled substance for invalid purpose, or they use street talk. They come in and they say, hey, I want the yellows, I prefer this over this. There are instances where people have, some type of either allergic reaction or something like that, but you should ask questions and dispel that suspicion. And we're going to get into documentation, but make sure you document, what these suspicions were and how you resolve that suspicion. Either write it on the back of the script or document it in your computer, however you're going to do it. Some other signs of questionable prescribing. For pain, acute and sporadic pain, they're prescribing several different kinds of short-acting opioids at the same time. Long-term prescribing of opioids for a short-term problem without a diagnosis of chronic pain. Getting down into chronic pain, there's routine prescribing and dispensing of drugs not recommended for chronic pain. High volume practice, typically a lot of times referred to as a pill mill. They're scanty notes. You call the practitioner and nobody can really tell you. They're like, he's got a bad back, or I don't have time to talk to you, or whatever it may be. That should be a concern. Continuing on, failure to document an appropriate reason for prescribing. There's no treatment plan. By the way, if there is a treatment plan, I would make it a habit to get that and put it in your files. Keep track of that. Prescribing many types of drugs with abuse potential for one patient. Prescribing or dispensing to suspicious individuals. Prescribing controlled substances to self or family members. That's usually a red flag you want to look at. Some of the common pharmacy red flags. These are the things that I'm looking at when I'm reviewing you. Do we want you to become a customer for us for controls? And after you are a customer, are you remaining a good customer? And I say that because we're required under the statutes to do our due diligence on whoever we sell controls to. So some of the things that we're looking at is, does the pharmacy have a high ratio of controlled versus non-controlled substances? The industry standard is around 14 or 15%. You should be at or below that for what your ratio is. Now, it doesn't mean it can't be higher, right? It could look like a red flag, but after talking to you, I could find out that, maybe you have you deal, mostly with hospice or long-term care. I'm going to know that because I'm going to get your dispensing information. I'm going to see that. I'm going to see who the doctors are. I'm going to research the doctors. I'm going to see what the facilities are. I'm going to ask you to identify those. So that would dispel that suspicion. Maybe you have a phentermine or a weight loss clinic next to your pharmacy. So, they're going to come in with just scripts for phentermine. They're not necessarily going to have other drugs associated with that. So there are reasonable exceptions to that, but you have to document it and you have to know what your business is doing. You shouldn't look like a deer in headlights when DEA walks in and questions you why your control ratio is 25-30%. You should already know the answer. It could be because there's a high percentage of cash payments for controls. We look at that. Typically scripts are going to be paid for and by insurance. So maybe you're in an area that's a lot of folks don't have insurance. So you want to document that on your patient file or on the script. Maybe it is a weight loss clinic, so phentermine isn't typically covered by insurance, so that would be a reason for it. But you got to know these things, you got to document those. What the pharmacy's rate of dispensing controlled substances far exceeds that of other pharmacies in the immediate area. DEA knows what you're doing. Everything that we sell to a pharmacy, we have to report to DEA. Every other wholesaler does the same thing. It's called ARCOS reporting. And so when they walk in your pharmacy, they already know what you've been up to. So you want to have the answers available. What they're trying to do is just confirm whether it's suspicious or not. So those are some of the things that we look at and that we have to justify to DEA of why we're selling to you. There's a clear lack of individualized dosing of medication by certain practitioners. Everybody's getting the same thing. Cocktail prescribing, right? That's a big one. It doesn't mean that somebody can't, there's no law that says a doctor can't prescribe that combination, but typically the courts have identified that as a red flag. It can be very dangerous on certain combinations of drugs, especially with, accidental overdose and death. So, and then another big one is that you as a pharmacist, you either don't listen or you intentionally ignore other warnings by other pharmacists regarding problems with practitioners in your area. The word gets out. We're talking to pharmacies all around your area, and we hear about doctors. We see every time we look at dispensing data for a pharmacy, we're also having to evaluate the practitioners and look at that. So we kind of know that. If everybody else is telling us about a certain practitioner, like you probably should be too. So you should know your doctors. When I walk in a pharmacy and if I say, tell me about your top 10 doctors, and I say, tell me about Dr. Brown, and you're like, I'm not sure. Well, if that's your number one practitioner, that's like a no-go for me. You should know who that is, especially your top 10. You should know where they're located, what their specialty is, who the patients are associated with them, because that's what DEA is going to do. DEA looks at that. They get a hold of PMP data and they research that. And they're going to ask these questions when they come in. They've already done the research, so you want to know it ahead of time. Be prepared. So how do you protect yourself? What due diligence can you do to protect your business, your livelihood, your license? The number one rule is documentation of your due diligence efforts. If it's not documented, it didn't happen. You can't later on when DEA show up and say, well, I think I might have done this or I think I might have done that. It's not going to fly. When I taught officers and agents search warrants and how to write those and all that stuff, what I basically said was, if it's not contained within the four corners of the document, it didn't happen. And that's the same philosophy I would like you to take out of this webinar is if it's not documented, you can't prove that it happened. So start documenting. Either put it in your electronic file, computer, or write it on the back of the script. Something when DEA walks in and they ask you the question, instead of getting nervous and not having an answer, you can say, just a second. And go pull up the file and say, look through it, read it, refresh your memory and say, this is why I did what I did. And that's going to go a long ways. Checklist, does the prescription appear to be valid and have all the required information? Did you verify the identity of the patient? Does the drug dose amount, duration, and quantity seem to be in normally observed prescribing patterns? Like I said, you folks are well educated. You're experienced. You know what the norm is. Whether you choose to ignore it or not is up to you, but you know what it is. So don't, if it quacks like a duck, it probably is a duck. So don't ignore it, address it. Your assessment of the patient, ask questions, talk to them. What did the doctor tell you about this? Or, tell me about what happened with your doctor. Get some of that background information and document it. Do you believe that the 6 fundamentals of a doctor exam were conducted? We talked about that. That's a big thing you got to look at and see, do you think that happens at the doctor's office? One thing you can do is visit the doctor's office. I used to do that when I would do a site visit at a pharmacy and there was a problem doctor. After I left the pharmacy, I would go over to the doctor's office and just walk in and sit in the waiting room for a minute. And I would just see what was happening. And I would see kind of evaluate the people that were walking in and out. And I would see, as well as I do, that a fast doctor visit is at least 30 minutes. And when you have people coming in and out, in 5 minutes, something's not right. You should recognize that. I did undercover work with doctors and at the offices and then ultimately at the pharmacy and all that stuff. And I can tell you, I've seen every trick in the book. It happens, so you need to be aware of that. You need to check internal patient profile records and perform drug utilization review. The PMP database, check that on your patients, especially for Schedule IIs. A lot of states require that you do it. Some states require that the practitioner do it and then they note it on the prescription, but make sure that that's being checked so you don't have shoppers. Make sure you verify the prescriber's DEA registration and the state license. Speak with the prescriber if necessary to obtain diagnosis codes. Have your talk formulated on what you want to say and why it's important, and work on a partnership of approaching it. Provide patient education. Nobody likes confrontation, but it's best to protect yourself if you just confront the patient and say, hey, what's the deal with this? And if they freely admit that they're going to go sell it or they're going to do something else, at that point, it's made easy for you, right? There's no guesswork, but talk to them. So back to due diligence, consider the geographical distances. This is what we look at, when we review dispense data. The distance between the pharmacy and patient, practitioner and pharmacy, patient and practitioner. Is the cash payment for controlled substances justified? We evaluated that. We call the pharmacy and ask those questions. Is the patient requesting early refills? Some of that's justified, right? Somebody may be going on vacation. But if they're coming in all the time and every time they say, I'm going on another vacation, you should probably question that. And then if you do discover something, I'm not suggesting that you be the police, but think about what it will do for you if you can document. Number one, it's just the right thing to do, but number two, think about what it can do if DEA walks in and they're questioning you about, what steps have you taken? Why did you do this? Why did you do that? And you can say, look, we've uncovered this, this, and this, and we reported it. Here's the date and times. This is who we spoke with, and that looks really good for you. For us as wholesalers, we're mandated by law in some states. We have to report if we have a suspicious order from a pharmacy. We're required to report that to DEA or the Board of Pharmacy or both. Some states require if we shut you off for some reason, either because you were too busy and didn't want to answer our questions or anything like that, we have to notify them. We have the same obligation. So I'm just, asking you to think about that and think about, how it can help you in the end. So accurately maintaining required records. It's very important. We're going to talk more about that later on. And then again, documentation is the #1 top priority for your due diligence efforts, documenting what you've done so you can show later on. Because when DEA shows up, it's never the day after. It's always months, sometimes a year later, 2 years later. You've read the news articles, right? During this time period, all this happened, and then it's like 3 years later, and DEA goes in and shows up at the pharmacy and the doctor and all that stuff. How are you going to remember that stuff? It's hard to remember, 5 patients ago. So the only way you can do that is by documenting all of your efforts. Remember this, The law does not require a pharmacist to dispense a prescription of doubtful, questionable, or suspicious origin. It's quite the opposite. To the contrary, the pharmacist who deliberately ignores a questionable prescription when there is reason to believe it was not issued for a legitimate medical purpose may be prosecuted along with a practitioner for knowingly and intentionally distributing controlled substances. A pharmacist is required to exercise sound, professional judgment when making a determination about the legitimacy of a controlled substance prescription. That determination has to be made before that prescription is dispensed. You can't let it go and then say, you know what, maybe I should ask some more questions or do whatever. It's too late at that point. You have to do all of that before. So this is what I want you to take away from everything we just talked about so far. If you're doing everything right, you are a licensed drug dealer. You're good to go. If you're not doing everything right, if you're not doing due diligence, if you're not questioning what you should be, you're just a drug dealer. And you're going to get arrested just like anybody else that would be selling crack cocaine or methamphetamine. And I'll point out what that law is later on. I'm not trying to scare you, but I just want to make it clear that that's what you face. So you should be aware of it, and you should take measures to avoid that. Let's talk about some of the DEA record keeping requirements. You're required to maintain complete and accurate records on a current basis for each controlled substance purchased, received, stored, distributed, dispensed, or otherwise disposed of. These have to be maintained for 2 years for inspection and copying by DEA officials. Some states require even longer. So, for example, here in Arizona, where the Phoenix distribution center is, where I, am working out of, it's 3 years. So we keep our records for 3 years. And your records must be maintained separately from any other pharmacy records or in such a form that they are readily retrievable. So, your bills for cleaning or your OTC products and stuff like that, they got to be separated. Everything associated with DEA record keeping needs to be segregated and kept by itself. Some of those required records are all your inventory records of controlled substances, including the initial and biannual inventories, your executed and unexecuted DEA 222 forms, or the equivalent, which is your CSOS certificate, right? So with IPC, once you receive your Schedule 2 drugs that you've done through CSOS, you have to go back into our computer and log that in, and that's your record right there. You can just go in and print that out at any time if DEA walks in your door. So that's the equivalent of that. You have to maintain your power of attorney authorization to sign order forms and CSOS. So if you've delegated authority for another pharmacist or even a tech, if you want, to order CSOS, you have to have a power of attorney on file, and I'll show you that in a minute just in case you don't. You have to have receipts and invoices for Schedules 3, 4, and 5 controlled substances, records of controlled substances dispensed, which would be your prescriptions, records of controlled substances distributed, so these are sales to the registrants, returns to vendors, distributions to reverse distributors, your DEA Form 106, so for any report of theft or significant loss, we're going to talk about that a little bit more in just a second here. Inventory of drugs surrendered for disposal, that's your DEA Form 41. Your DEA registration certificate, right? That's basically your license from DEA to possess controlled substances. And here's a big one that we'll talk about. And don't worry if you don't have it, don't panic. You can get a hold of me in the days to come, and I'll just walk you through it over the phone on how to get this. But I find a lot of pharmacies that I go into don't have this. They aren't even aware. Or you might have the certificate, but you don't do the required training. So what this is the Combat Methamphetamine Epidemic Act, otherwise known as the CMEA. And you're required to do a self-certification, have a certificate and post it on the wall right where your DEA registration is, have a logbook, and there's also required training. So this is the power of attorney form, and if you have questions about this in the coming days, I'll provide you with my email address, and phone number, you can get a hold of me and I'll walk you through it. But again, basically this is what gives the, in most cases, it's the owner of the pharmacy that obtain the DEA registration. So you would be the one authorizing other people to order Schedule II drugs. If it's a corporation, it has to be a corporate officer that authorizes someone else to do it. So just keep that in mind. We have a checklist that we're going to get to you. I just realized I forgot to get that to Linda to send out to everybody. We'll get it to you here in the coming days. For those of you that have had a site visit by DEA, especially by me, we leave this with you. It's our checklist that we've prepared for you. And it's kind of the nuts and bolts of what DEA is going to look at when they come in to do an audit of your pharmacy. It's not all inclusive, but it hits all the high points. If you have this stuff in order, you're going to do really well. So we'll kind of talk about those things. Here we go. So DEA requires a biannual inventory. That means at a minimum, once every 2 years, you have to do a complete inventory of 2 through 5 scheduled drugs. And I always recommend that you do it more often. Some states might require it once a year, some might require it every 6 months, whatever it is. But at a minimum, you have to do it every 2 years. You have to put on there whether it was the beginning of business or close of business, and that's very important. It's required under the regulations, but it's important for DEA or the Board of Pharmacy, for that matter, to distinguish where they start their audit from. If you did it at the beginning of your day, beginning of business, then they would know they would start, calculating everything throughout the rest of the day. If it was at the close of business, then they would start calculating at the beginning of the next day. So it's important that that's annotated on your inventory. You can handwrite it, type it, whatever you want to do. Your biannual inventory and all other inventories have to be separated into a Schedule 2, one for Schedule 2 and then one for Schedules 3 through 5. So just make sure they can be in the same book or however you want it, but it has to be separated because DEA is going to typically come in and just say, I want to see your Schedule 2 inventory right away. So, it has to be separate. An inventory is a complete and accurate list of all stocks and forms of controlled substances in the possession of the pharmacy. That's determined by an actual physical count for Schedule 2s and an estimated count or measure of 3 through 5s. That's actually what's in the regulations, but I can tell you that most likely they're going to do a physical count, so just be prepared for that. And also, it also requires that if it's a container that holds more than 1,000 tabs or caps, you have to do an exact count of what's in there. Schedule 2 inventories have to be kept separate. I've already mentioned that. And your inventory records must be readily retrievable. So it can't be stored offsite or anything like that. It has to be, if they walk in and say, I want to see it, you got to produce it immediately. There's 2 types of inventories. There's the initial inventory. That's when you first open your pharmacy, you first get your DEA registration, and that count should be 0 because you didn't have anything. You couldn't get any until you got that DEA registration. Then after that, it's always a biannual inventory or sooner that you're going to have. Your Schedule 2 CSAUS receipts and 222 forms. You got to remember that with CSAUS that you have to annotate with the quantity and date received in the computer. So for IBC, we don't do paper 222. It's all CSAUS. So after you receive it, make sure you go in, log in, and go to the website to your account and annotate. Check off that you've received it and all that. Other companies, other wholesalers do that as well too. So if you're not doing that for them, check and make sure you're not supposed to be doing that. And then for your paper 222s, make sure that the ship quantity and date filled in. Typically, if I look at an audit and I look at that, I typically find those columns missing. Those are the columns on the far right for date and quantity. Also, sometimes I'll find that the pharmacy is holding on to a form that the green form that should have been shipped to DEA. So double check that stuff. And you also are required to report any lost or stolen blank forms to DEA. They're a tracked item. Your Schedule 2 invoices, they have to be readily retrievable and separately filed. They need to be by themselves. Your Schedule 3 through 5 invoices have to be separately filed with dates and quantity received. So the invoice or packing slip is the official record of receipt. All records must be readily retrievable. They can't be mixed in with your non-control invoices. I always recommend if you're going to circle the, however you're doing it, whether you're circling the quantity on there and writing the date or whatever, put initials or sign it or whatever. So you can always go back and know who did it, who was responsible for that. Schedule 2 prescriptions, they have to be readily retrievable and separately filed. So you can see the pattern here, right? And this is, and again, some of this stuff is, you know it, you've been doing it for a long time, but it's just a refresher. You would be surprised how many times we go into a pharmacy and we see stuff commingled sometimes. So we just want to make sure we're getting everybody back at homeostasis on what needs to be done. Schedule 3 through 5 scripts have to be readily retrievable. And I want to just give you a refresher on this again for prescription records. So option 1, you have a file for Schedule 2s. That always is what you have to do. And then you have a file for Schedule 3 through 5s. And then you have a file for non-controlled scripts. Or option 2 is, again, you have that file for Schedule 2s. And then you have a file for 3 through 5s and non-controls. They can just be commingled together. But if you do that, you have to do one of two things. Either that controlled script has to have a red C stamp in the lower right-hand corner. It has to be an inch high or more. Or if it's electronically filed, so it's electronically retrievable, like you can just say, prescription number, whatever, and pull it up in the computer. That suffices too. That's covered under the regulations. So either one of those is sufficient. Let's talk about theft and significant loss reporting for a second. So as a pharmacist, you have to be familiar with the procedures for theft and loss investigating. A theft, remember, is this. It could be an internal theft, right? An employee steals some controlled substances, and that's any 2 through 5. It could be somebody comes in with a gun and it's an armed robbery. That's a theft. Or it could be while the pharmacy is closed, maybe over the weekend, and they burglarize the pharmacy, they break in and they steal your controls. That's a theft too. So that has to be reported without question. Significant loss is very subjective. It could mean one thing to you, one thing to me, and it could mean something else to whoever the DEA investigator that comes in. So I usually use this example just to kind of get my point across. If you're a manufacturer and you are missing 10 oxycodone pills off the assembly line, that's probably not a significant loss, right? They're doing thousands, millions. If you have a 100-count bottle of Oxy 30 and you're missing 10 from that, that might be significant. So just think about it in that approach. If you're dealing with a liquid or something like that and you spill some, that's probably not significant. Maybe you crush a pill accidentally, something like that, that's not going to be significant. I always recommend that anything that you don't report is just keep a log of it so you can account for it, because you also might want to, maybe you notice a pill gone here, another one again. It might be a trend. It might be related to an internal theft or something. So that little log that you keep could help you determine that. You're required for any of those circumstances to notify DEA within 1 business day in writing. So you're going to notify your local DEA office. You can, either in writing or email. You should notify your board of pharmacy, your local police agency, and then the follow-up investigation. Once you determine what's been stolen for sure, you have to file your DEA 106 electronically. So you go to the DEA diversion website and do that. Right now, it's kind of a, it's like a unofficial 30-day time period, but it's pretty soon here. It's going to be official where you have to do it within 15 days. If it, you should be able to do that. Number one. Number two, if you put in what you can, and then you can always amend it later on. So don't panic on that. Talk about in transit loss for a minute, because it is a loss. So when a shipment fails to reach your destination, your pharmacy, the supplier, which would be us, is responsible for reporting that loss to DEA. If the pharmacy is responsible for reporting the loss. If you've received it, you've taken custody of the shipment, and then you discover that the items are missing, you're responsible for reporting that theft or loss. If it's delivered to your pharmacy, you notice that the package has been tampered with, and you say, you know what, I'm not going to take it because it looks like there might be only one bottle in there, and I'm not going to open it. I can only feel one in there, and it comes back to us. We, as a distributor, are responsible for that. So just if you're wondering how that works or who's responsible. So that CMEA Act that I talked about, you have to conduct training. You have to print your certificate. It has to be posted. What I recommend, and again, don't panic if you haven't done it. I'll get you squared away. You can do it. And then what I recommend is that there's a PowerPoint for the training. It takes about 5 minutes to read through it. I recommend that you print it out, create like a sign-off sheet for all your employees, have everybody read it and sign off on it, and then keep that in a folder. And then you can also probably use that for maybe some required training or something, that you can show that you've done. It applies to all retail sales for over-the-counter product containing ephedrine and pseudoephedrine. These products have to be placed behind the counter. You got to check ID. You have to log them. I'm sure you're all pretty much familiar with that. If it's a prescription for it, though, you don't have to worry about that. If you only take prescriptions for pseudo or ephedrine products, you don't have to worry about it. It's only if you sell over-the-counter products containing that ingredient that you're required to keep behind the counter and log. So the power of attorney, you got to make sure that you have these on file for anybody that orders CSAUS. You got to have the copy there. A copy has to be sent to DEA. And if it's if you're doing that's for the CSAUS and 222, and if it's CSAUS, you got to make sure everybody has their own digital certificate that was granted that POA. The powers of attorney are executed by either in most cases, it's going to be the owner of the pharmacy, but if it's corporation, it's going to be a corporate officer. So just keep that in mind. You got to have a CSAUS subscriber agreement on file. You probably don't have it. There's not one pharmacy that I've walked in. I've been in several hundred. And nobody has had it. Most people don't realize you got to have it. I wouldn't panic. If you absolutely needed it, you could go print it off the DEA website and say, well, I have it. What I recommend is that you do that ahead of time and just keep it in a folder. Again, in the coming days, just let me know. I can get a hold of you. I can show you how to do that and print it out, and then you'll just have it. It was something that you agreed to when you got your CSAUS certificate. And then you have to ensure that you aren't sharing passwords. I know it's common. I've come across it in times before where I say, how many people are CSAUS? There's 3 of us, and well, how many passwords? Well, we share it. That's a big no-no. DEA is going to revoke your ability to do that, and they may even sanction you for that. So if you're doing it, stop and work through the process to get everybody a separate password and CSAUS certificate. Let's talk about some other requirements real quick. Minimum storage, that you're required to store controlled substances in a secure locked cabinet of substantial construction, or they can be dispersed throughout your stock of non-controlled substances. Some states, might require that you keep it in a locked cabinet. Now, there's nothing in the regs that specify or define what that construction of that cabinet is. So typically, we're going to see some type of, metal cabinet or a gun safe, but it could be made out of wood. It just all depends on, where you're located, what the potential is for theft. So you just have to consider those things. Some factors when evaluating that might be the number of employees, customers, et cetera, who have access. The location, are you in a high or low crime area? Do you have an alarm system? Do you have prior history of theft or diversion? Something else you might not be aware of, the law requires that you cannot employ any person who's in a position that has access to controlled substances, that has been convicted of a felony related to controlled substances. So if it's a felony related to, maybe they wrote some bad checks or something like that, that's not related to controlled substances. If they were, a drug dealer or something of that nature, you can't do it. You could get, possibly sanctioned for that. There's a waiver for that. It's under Title 21, 1307.03, and it's in the pharmacist manual as well too. So you can look that up. Hopefully you don't have that situation, but if you do, address it now. Also, just to make sure you're aware of the DEA 5% rule, pharmacies can dispense controlled substances to another pharmacy or practitioner without being registered as a distributor. But it can't be more than 5%, and it has to be, the transfer has to be documented on the 222 for Schedule 2s, and then on a invoice for 3 through 5. So how do they figure out that 5%? It's the total number of dosage units of all controlled substances that you've distributed cannot exceed 5% of the controlled substances dispensed by your pharmacy during a calendar year. So that's what the rule is. So, a lot of people, if you have maybe a small chain or a sister pharmacy, or maybe you have a friendly pharmacy down the street that you help out now and again, just know that you can do it, but it can't be more than 5% rule, and make sure you have the documentation. Let's talk about DEA inspections. Again, we talked about DEA has added pharmacies to their inspection schedule. They're going to do a full-blown accountability when they come in. That audit must balance. It's got to come out right. It can't be off. If there is any discrepancy there with record keeping or anything like that, there could be administrative or civil actions could be imposed on your pharmacy. There's 3 types of written notices that DEA is going to use to inspect your pharmacy. Sometimes they may just come in to talk to you and say, hey, we're looking at this doctor. Do you have any scripts related to that? They may just be, looking to do follow-up on something they're investigating. But if they come in with a notice of inspection or an administrative inspection warrant or search warrant, you don't have any choice in the matter. You have to comply. If they just come in, asking questions, whatever, you can choose to be helpful or not. I always recommend be helpful, but that's up to you. But if they come in with a notice of inspection, this is what it looks like, and you'll notice that it says right on their notice of inspection. This is where they're typically coming in to do a scheduled audit, or maybe it's a surprise, audit or inspection. You have a right to refuse them to do this, or you have a right to refuse at any point while they're doing it. Again, if you refuse it, the chances are they're probably going to leave and they're going to come back with an administrative inspection warrant, which you don't have any choice. But again, just know what they look like, know what they mean, know what your rights are, and understand the process. This is what an administrative inspection warrant looks like, and it's going to say warrant for inspection. You don't have any choice. This has gone to a court, a judge has authorized it, and you got to comply. Don't think you have that this is one where you can just say get out of here type thing. So just be aware of what it looks like. And this is what a search warrant looks like. It's going to say search warrant right on it. And again, if you have somebody coming in with a search warrant, you should be concerned. You should probably be worry about what you're saying, what your employees are saying, and you might want to contact an attorney to assist you, but just be aware of it. So this is kind of and on that handout that we'll send to you, that checklist, this is on the back of it, and this is kind of what the audit is going to look like for DEA. They're going to take, they're already going to know what they want to look at. They're going to take some Schedule 2s, and they'll probably grab a Schedule 3 or Schedule 4, and they're going to look at your opening inventory. They're going to compare that with what you had for purchases during the time period, and that's going to give them your total accountable for, which in this case, if you look at oxycodone going across, it's 3,600 dosage units. Then they're going to take your closing inventory. They're going to have you count what you have on hand. They're going to look at what you've dispensed through prescriptions. They're going to look at any returns that you've done, and they're going to look at any DEA 106s or 41s. And then that balance is going to come out, and it should be the same. Total accountable for, total accountable for. It's that simple. It should look like the one in the last line, the clonazepam, and if you look over to the far right, you're 500 dosage units short. that would not be good. So you don't want that to happen. So this is just exactly how they're going to do it. Some of the DEA actions that they can take, there's criminal action through the U.S. Attorney's Office or through state courts. There's civil action through the U.S. Attorney's Office. There could be an immediate suspension of a DEA registration. This is already going to happen ahead of time. They've already gone and made their case with a hearings officer, and they're going to walk in and they're just going to tell you your DEA registration is suspended. There could be a revocation of your DEA registration. That will be a hearing which will happen after the fact. And then there could be a restriction on your registration. So they come in, there's some issues, and there may be a MOA that they place on that. They say, we're going to allow you to continue, but you have to abide by this, this, and this, and they're going to make frequent checks on that. There may be a letter of admonition. They may say, you know, we're going to keep this in the file. If you do this again, then there's going to be more severe consequences. Or there might be a referral to the state agency or board. They might just say, there's really nothing here we're going to do, but they notify the Board of Pharmacy. And just so you're aware, Board of Pharmacy and DEA work hand in hand all the time. Board of Pharmacy may be called DEA in and vice versa. Under the criminal statutes, this is where you get charged as a drug dealer under Title 21, Section 841. It's illegal distribution of dispensing of a controlled substance. If that prescription was not issued for a legitimate medical purpose in the usual course of their professional practice, and it wasn't dispensed in that same manner, you're a drug dealer. And that's how it's simple as that. And that's what you're going to be charged with. That's what you'll be arrested for. So keep that in mind. Civil, these are more of your record keeping violations. These are, you know, things of that nature where, you know, they're just going to fine you. And those hurt, especially as an independent pharmacy. You can't really, you know, take a hit like that. So a lot of times when we do these education things and we talk about the CMEA certificate that a lot of people don't have, or we talk about the CSOS subscriber agreement that people don't have, there's $30,000 right there that we would have saved you. So again, don't panic. We'll get you through it. It's likely DEA is not going to show up at your doorstep here in the next couple of days, but we'll do that. So, wow, that was it. I squeezed it all in. I'm surprised that we got it. We're 1 minute shy. So I just want to thank everyone. My contact information is there on the slide, my desk phone number and my email. You know, thank you for joining us for this webinar. I hope you found it informational, useful, and you know, the information was useful. You know, email me if you have any questions. Hopefully, you had some questions that came in. We'll get back to you here in the coming days with answers for all of those. And stay safe. Thank you very much.